welcome everyone. We are about to watch the rebuttal of Trump's lawyer and then of the state's lawyer in Nevada. Trump's lawyer has made these wild allegations, and I'll play one for you right now. I'll play the response of Kevin Hamilton, the lawyer for the people, saying, hey, let's not overturn the whole election. This is, and this is true, this is the dumbest argument I've ever heard against an election. Trump's lawyer literally said if one ballot in a batch of ballots or in a county is wrong, if one ballot is fraudulent, you have to throw them all out. The election cannot stand. That's how important it is. Which, I'm sorry, no judge is going to stand for that. Even the crooked judges in the movies will, even the insane judges. That's just insane to say. Let me find, I'll pull up the video that I just captured of the argument from the lawyer for the people against Trump. This is Kevin Hamilton. Let me make it so that you guys can hear it. That would work better. It appears my camera's working. I don't know if my skin looks smoother, so I think the filters are still there for those of you who are watching earlier. By the way, my name's Kevinly Father. Okay, I am your Kevinly Father. My name's Kevin Williams. This is the live stream. This is what we do. We chat truth to power. Join us in the chat room over there. Just chat on whatever template you're using, whatever platform. Twitter, Twitch, whatever. It all works. It all goes over there. If you want the fastest chat, go to youtube.com/KevinlyFather. Find us there. youtube.com/KevinlyFather. And from there, you should be able to find the live feed. YouTube should show it to you. Be sure to subscribe and click the little bell on YouTube so that way you get alerts so that when we go live, you can join us like all these good people over there. If you want to help out the broadcast, go to paypal.me, blah, 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 Venmo, blah, 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 KevinlyFather.com. You can become a patron. And I am working on the t-shirts. Actually, executive producer Rich is working on the t-shirts with me. So I will be bugging you. Those of you who contribute more than $25 a month on Patreon at kevinlyfather.com, you will be getting t-shirts. I will be contacting you shortly with your size. If you're watching right now, send me your size. If you're of t-shirt, not all your sizes. I don't. Here we go. This is the lawyer for the people, Kevin Hamilton.
Mr. Aaron testified. Yet contestants stand before you and boldly allege the wildly implausible that over 42,000 Nevada citizens committed felonies by voting twice in this election. 42,000. You'd think that anyone leveling that sort of a charge would have powerful proof. But contestants don't. They can't even name them, or perhaps they don't want to name them because of fear of liability of accusing somebody of a crime that's obviously defamatory. They can't prove that any of those individuals even voted in the presidential election, and they certainly can't prove for whom those ballots were cast. This is an utter failure of proof on every level. Charitably, one might call it junk science, unreliable on its face, and offered by an expert who is no such thing.
Thank you, Slick Chick, for some Super Hearts. I think that's Periscope. Thank you, Leslie, for Super Hearts. Again, that's Periscope. I am now Tier 1 of Super Hearts. Still don't know what that means, but it makes me feel good, and I appreciate it. Thank you very much. I think I now qualify for something from the Super Hearts. Those are actually worth money to me, as I understand it, and I really appreciate it. It helps us keep going. Now, those arguments have been made. The initial arguments have been made. Now we get the rebuttals or the final comments. This is the judge in Nevada. Let's watch. The judge is difficult to understand, but you can understand the lawyers.
Better pick up on the mic if this stays seated, so it's no disrespect to me or anything else, and I won't take it as just being disrespectful.
Thank you.
And I won't hold it against you. So.
I appreciate that, and I thought with the mic being at this level, it might be easier, but I appreciate the court bringing that up. Your Honor, this is a breathtaking case, and the evidence that we put forward is breathtaking, and there's no other word for it.
I couldn't hear what word he said, so if it was crap, he is correct.
I want to discuss some of the items that
this Trump's lawyer,
the opposing counsel brought up in his argument. talking about how ballots decide elections, and that is the way it's supposed to be.
Yes.
But there is nothing more at the heart of our representative democracy than one person, one vote, and limiting elections to the citizens of that state. Only legal vote should count, but every legal vote should count.
Same guy who argued that if one is fraud, all the legal votes get thrown out as well.
And in order to make sure that we are in a system that promise is kept, we make sure that there's meaningful observation. The record is clear, and you can look at does 1, 2, 3, almost all the does 1 through 7, to see the failings that happen in transparency. Transparency is not political. Transparency is something that is necessary for us to have a democratic election, to have integrity in that election so that we know that it is the candidate chosen by the voters that is the one actually elected. As far as the pleading status go, when you read the statute and the specific requirements of the statute, and the part of the statute they are citing is saying that the contest is not normally supposed to be struck for lack of form, it would make no sense for that sentence to be read as increasing Nevada's pleading, notice pleading requirements. It was read to put them on notice of the claims. It did just that. The contest went through and did point out and gave notice for everything we would bring up to the court. The statute, we met and exceeded the statute as much as they may wish, the defendants may wish, to add to that requirement. Nevada law does not. Likewise, they have tried to add to the requirement of Nevada law by requiring us to supposedly put in the very specific voters that we think cast unlawful votes. Now, of course, they objected to any depositions. They objected to 15 depositions. We certainly couldn't take 40,000 depositions. We couldn't take 130,000 depositions.
You could have taken one.
We put forward the evidence, and with our data scientists and putting into the record the data, much of the data that was relied upon, we have shown exactly the methodology used to prove the unlawful voters. And the defendants may certainly want to wish to raise the bar more than the legislature in Nevada did, but they should not be allowed to do so. In fact, it's quite honest that they can't attack the data itself. So instead, they try to attack the data scientists. And they have a deposition where counsel testifies a lot about what counsel may wish the data scientists to the things like error rates. But of course, they have no actual testimony that those error rates
Thank you, Shauna, for the super heart.
Are something that would affect the result. Even though they're
yeah, he's not great, this attorney.
Mr. Kamsel provided the exact methodology and the exact databases that he used to do the matching so that they can recreate it, so that they can go through and test his conclusions. They bring nothing to say that those conclusions are wrong. And specifically...
Well, he's thirsty because he's been eating so much applesauce all day long. Not to mention the Jell-O.
It must be pointed out that the most striking number is the over 40,000 people that voted twice. And the best response they can come up with that is, wow, that sounds like a really high number. It must not be right.
It does.
But when you have the situation that we have here, where ballots are being sent all through Nevada, and often more than one ballot to a person, and often to people who have changed their names because they've gotten married or for other reasons.
Here's what they did. Some people got 2 ballots if they've registered to vote twice or whatever. Nevada before this year has never had the universal mail-in, right? So what happened this year was the Nevada state legislature and governor decided, originally the governor and then the legislature went along with it. They all agreed everybody should get a ballot. So everybody got a ballot, okay? Not just an application, but an actual ballot. Some people had moved. Some people had died. This happens every single year. A very small sampling was taken and said, oh, look, this person got 2 ballots, one under their married name and one under their maiden name. Therefore, we can extrapolate that and say that 40,000 people voted twice. That's literally their argument. Although they have no evidence of anyone voting twice, he's off going now. It's, oh, yeah, well, you can't prove that they didn't vote. That's their argument.
We see that in the passion of the moment, people would vote twice.
Because they're passionate.
And
Donald Trump is such a terrible president that it is completely plausible and, nay, scientifically proven that people in the passion of the moment will commit felonies and vote twice just to get rid of Donald Trump. I'm sorry, what? Hold on. Oh, my applesauce next to me is telling me that it's against Biden. They're passionate against Biden. Thank you.
that is why that number, while striking, is important. Mr. Kamsel used and explained the methodology that he uses in his profession, and
Mr. Kamsel is the expert.
he has used for well over a decade. He's used it in political data when he does it. He's used it not for purposes of being an expert witness in political data, but to make sure that when using a campaign or when executing a campaign, they have the information they want to have on voters. That this is the methods they use. He's also used it on behalf of corporations. He testified to that in a deposition. It has to be something that is testable. The deposition, he goes into great length. The methods he used.
Watch what I can do here, okay? Watch. Biden voter, Biden voter, Biden voter, Trump voter, Trump voter, Biden voter. It's that easy. It's that easy.
To come up with these, and so that he can come and form his conclusions to a degree of reasonable certainty. He's met the standards of being an expert, and any other met and exceeded them.
Michelle's right. At a rally in North Carolina, and multiple times, Trump told voters to vote twice, to vote once by absentee, and then go to the polls, make sure that that went through, and vote again. Kevin McCarthy did the same thing.
Any other arguments they have simply go to weight, not to the admissibility, and the weight should be quite large, being that their attacks on the data themselves are quite honestly weak. Regarding Doe 3.
Okay. Yeah. You're the best. Oh,
I'm sorry. Regarding Doe 1, they said that there was no evidence that Doe 1 actually saw people changing votes. This is the very nature. This is probably the best example I've ever seen of circumstantial evidence. When we talk about circumstantial evidence, and if we're going to try to explain it to a law class, this would be the example you use. You don't actually see somebody changing the votes, but at night it has one number on it, in the morning it has another. Circumstantial evidence that sometime in the night, something happened to change those numbers. That is circumstantial evidence, and that is striking.
It is admissible in court. People are like, well, that evidence is circumstantial. Circumstantial evidence is, for example, you wake up in the morning and the ground is covered with snow. That tells you, reasonably, that it snowed overnight. You didn't see it snow. That would be direct evidence. But it's circumstantial. Oh, that makes sense. The same thing applies to hearsay. Hearsay is something that can be admissible in court.
They talk about Doe 3, and they can't impeach her credibility. They can't impeach what she saw. They just said that it's crazy that it happened. It is crazy that this was happening in this election. It is so unfortunate that this election was administered in such a way that it was ripe for fraud, such as people packing the ballot box. And they say that they don't know that those ballots that she saw were cast. Well, of course, she didn't follow them to mailboxes. She didn't see what they did. But she saw them putting them into the return envelopes. And when she put that, and that, of course, there's no reason for someone to fill out a ballot, put it in the ballot return envelope. There's no good reason to do that.
What?
When you're stuffing ballot boxes, it's clear. That, again, may be circumstantial evidence, but it's striking evidence.
Circumstantial, nonetheless.
And of course, the circumstantial evidence is worth no less weight, especially not with someone whose credibility is so strong.
For a statistician to use circumstantial evidence, though, is not as strong. And that's all there is to it.
Your Honor,
it becomes supposition. Ah, Sean. Hey, Sean. Everybody. Sean is. Am I getting this right? I'm not gonna. Hold on. Go back to what you were doing. Ignore me. Nobody listen to the Jello.
On the Agilus machine.
The Jello machine?
The most important thing about the Agilus machine is something that they can't answer, and that's the fact that the use of it just wasn't authorized by the statute.
Yes, new patron in the Dollar Shame Club, Sean Combin, just joined. So, Sean, thank you very much for becoming a patron. If you'd like to become a patron, you can. You may. I will permit it. Go to kevinleefather.com, just like Sean did, and Sean is our newest patron in the Dollar Shame Club, except it's the Pound Shame Club. So I got to come up with a better name then. So it's a pound, and I appreciate every single dollar and pound. I appreciate the pounds more. Everybody loves a good pounding. Trump's about to get a pounding from this judge here. What's a better category than Dollar Shame Club for Sean? Because it's a whole pound. There's Heyo.
And then you take and you look at the other evidence of what happens as a result of that.
Yeah, pound 20.
Not just as a result.
Sean, we call that pound venti.
Of
that might be the name of your club, the Pound Venti Club.
Of the Agilus machine, but as a result.
That sounds like a movie with Tom Cruise.
Of the people that were hand matching signatures.
But in this movie, he'd be in the closet. He'd be on the down low. Down low at Club Venti. Pound Venti. Pound Venti. No, just Pound Venti. We just call the movie Pound Venti.
Of course,
the Pound Venti.
The evidence. The machine was matching about 30% of signatures, and then it took human beings to match about the other 70%. But there's all this pressure. You see it from DOE 2, you see it from DOE 3. There's all this pressure to push through the signatures in order to just authenticate them. You see evidence of stars and shapes being used to authenticate a signature, and when a poll worker then takes and brings to their supervisor's attention that says, this is a star, it's not a signature, they're told, push it through. And when you see such a low error rate on the signature matching,
I can't help anybody with the stars and shapes. I'm terrible with shapes anyway. I mean, really, I'm a Jello mold, so what the hell do I know?
You understand why it is so critical that there was not a robust effort to match signatures. They were putting more emphasis on their employees to get it done quick than to get it done right.
Quickly.
And if you want an election with integrity,
you're going to talk about something being done right, say quickly.
If you want an election that you know that the person with the amount of votes at the end that's being reported is the person who had the most legal votes cast for them, you have to make sure it's done in a way that ensures integrity. And the evidence is they failed to do that. They wanted to push it through. There's evidence time and time in these declarations, and reading the declarations of the whistleblowers in this, the depositions of the whistleblowers is so critically important. In 1 month, we have put together striking evidence that because of the lack of transparency, because things were rushed, this election was unfortunately stolen. The court asked the question about
That's unfortunate.
knowing who voted for who. Well, we know that the vast majority of the problems came from Clark County, and we know the vote difference between the two candidates in Clark County. That would be one way to reach that conclusion. We also know that all the evidence of fraud that we brought to the court's attention, all the evidence of fraud that we know of in Nevada has only come from one side, the Biden side. We cannot turn a blind eye with striking evidence like this. We cannot allow an election to be stolen. We cannot pretend that these voter irregularities and this vote fraud didn't happen. We ask the court to grant the contest. We appreciate the court.
Hamilton, do you have any final comments?
No, Your Honor. I think the case is properly submitted for you. We have the case dismissed. Thank you.
Thank you. Well, first of all, given the time constraints involved in this matter, I'd like to thank the parties for their briefs, their arguments, their excellent arguments, and respect that. I know this wasn't an easy case by anybody in respect to contestants or basically defendants, given the short time and the period in which it was involved. And again, the court tried to accommodate everybody as quickly and possibly as I could in respect to all the issues and motions I was getting. And I tried to rule as quickly as I possibly could, considering all the other matters going on with the court, to be honest with you. Again, given the nature and importance of this position, the court would like to review the evidence.
Don't go away.
The arguments made.
What the hell?
To certain evidence records, which I would like to verify and take a look at, to be honest with you. The court orders each party to provide a proposed order, which includes findings of fact, conclusions of law, and a decision by 10 a.m. Tomorrow morning for the court's consideration. Now, I picked that time because it's Friday, 10 o'clock. It's the court's intent to get the decision out so that there's time to go to the Supreme Court if anybody wants to go to the Supreme Court in respect to this particular matter.
We're not going to get a ruling right now.
That we look at the reliable, credible evidence.
Thank you,
in the
Michelle.
rule of law, looking at NRS 293.410. And again, and this comment goes to primarily to the defendants. It's the court's preference to really decide this matter on the merits, not on just dismissing based upon a claim that basically there was not sufficient certainty alleged in respect to that. I'm not saying that's not a valid claim or not. It's just my preference when you do your findings of fact and conclusions of law that you go through the merits more than anything. So again, thank you on behalf of the court. I appreciate it very much. Thank you.
Okay, so we're not getting the decision. Basically, he's asking for finding of facts, which is like, okay, so give me more. Tell me more why you think there's actual fraud, because nothing that the experts said actually proved that there was any fraud, like everybody else. So, welcome, Michelle. You get invited to we're gonna have movie night tomorrow. Let's say 6 o'clock. No, that's kind of late for everybody. We're gonna watch Elf tomorrow. We're gonna watch it on Zoom. So if anybody else would like to be part of the Zoom meeting, I don't know, DM me on Twitter at KevinLeeFather. Yeah, that's the best way to get a hold of me, I think, is at KevinLeeFather. DM me or send me a message. Because if I don't follow you, you can't send it to me. I don't know. All I know is that the people who do Patreon are going to get... if you want to come to our Zoom meeting tomorrow, and you're not a patron of the art already, if you're not already a patron of Kevin Lee Father and or Red Jello, say something in the chat room, and somebody figure out how they can contact me and let me know so I can invite them to the Zoom meeting. That's what I'm saying, in a very roundabout way. We're gonna watch Elf tomorrow. Let's say 5 or 6. 6 is 9 o'clock Eastern. Is that too late? Is there anybody that it's too late for you? Not the Europeans, because I can't help you guys. Is 6 p.m. Pacific too late? Oh, I know, Michelle. We follow each other, but is 6 p.m. too late tomorrow to watch Elf with everybody over Zoom? If we can make that happen, there's no guarantees that we can make that happen. 9 is not too late. Okay, thanks, Liberty. So there you go. But let's go find the hop. Oh, baby, let's go find the hop. Hold on, I want to find the other case going on right now in Georgia. Let's see if that is still live. We can do that by doing this. And here we go.
As the mayor said, complimenting the minority for their approach to this, I would disagree with one of my colleagues in one regard. The comment that we don't need these hearings. I really could not disagree with that more strongly. We need these hearings. Our voters, our citizens need to see us having these hearings because
Tracy, send me a DM on Twitter, or just put it in my Twitter feed that you want to go and I'll follow you or something. At Kevin Lee Father on Twitter.
Because they need to know that we, as their representatives, are willing to investigate wrongdoing. Do we need the truth, Senator? You're absolutely right. We do need to get down to the truth. But I want to take it one step further. We need to have accountability for those that have engaged in wrongdoing. That's the next step. That is the step beyond fact-finding and truth-gathering.
Oh, you know what, Tracy? I think you can just send me a message on YouTube. Hold on, because I do get YouTube mail. Let me make... Yeah, guys, you can do that, right? You can send somebody a message on YouTube.
We've got to have accountability. You can't have accountability if you don't have these hearings. If fraud and impropriety are occurring, you can't stop it by just lamenting after each election, wow, that was a mess. I hope it doesn't happen again.
Yeah.
It won't change.
I don't know that you can. I think Twitter's the way to go. So yes, I'll watch my Twitter feed right now, and if anybody messages me on Twitter, I'll follow you, and then we can DM each other, and we can figure this out.
We cannot expect anything to change with regard to what seems to be the perennial fraud and impropriety in certain precincts and certain areas that occurs every election unless we start and decide to have some form and measure of accountability for those that engage in fraud, those that engage in wrongdoings, and choose to violate our law. Mr. Chairman, thank you for your patience. Thank you for staying late. I appreciate your leadership on this committee. Thank you. And I thank all my colleagues for being here.
Senator, is that?
Say so.
Mr. Chairman, thank you for allowing a non-member to sit at the table and be engaged in these topics. Guys, I've run 4 elections in 1 year.
Okay, so these are just the thank yous. Let's go back and see if we find anything interesting in here.
In 2016, yeah.
Here we go. Here's Rudy talking. Let's go back from Rudy. Well, they had a constitutional law professor, Eastman, coming in, and he was wrong about just about everything. Let's go back to, there were some questions for him. There was an interesting bit here. Here we go. This is Rudy's buddy, John C. Eastman. He's a constitutional law professor, and surprisingly not good. He's got himself a nice gold Zoom background. Go with a Jell-O head, dude.
And that's a change from the
If I have to testify in one of these hearings, I'm totally going Jell-O head.
statutory protection against fraud that the legislature had adopted that was not complied with.
Well, you and I have I'm not sure that's correct. I think it's checked twice. And I think that's what the guidance said.
Existing procedures are not followed. And when significance...
I try to be fair to the
We'll go to their argument.
And former dean at the Chapman
The Electoral College process. And I believe
senior fellow at the Claremont Institute.
Thank you. Professor Eastman, I believe you're going to talk to us today about the Electoral College process and how that affects the legislature here.
Sure. Thanks very much. And Chairman Ligon and the members of the subcommittee, thank you for inviting me to testify at this very important hearing. My scholarly work and expertise have always revolved around the structural provisions of the federal Constitution. And because of that, similarly, 20 years ago, I was invited to testify before the Florida legislature as they were dealing with issues similar to what you're dealing with now. At that time, no one had given much attention, scholarly or otherwise, to the role the Constitution assigns to state legislatures in determining the manner of choosing electors. And it's a little bit foreign to us now because we haven't really done what the Constitution authorizes fully for a very long time. The last time the issue really came up was in the election of 1876, and I don't think any of us, maybe Mayor Giuliani, I don't think any of us were around back at that time. But in the wake of that controversy, Congress passed the Electoral Count Act of 1887, and which aimed to clarify some of the processes.
This is what I've been talking about.
That act, too, didn't get much attention until the 2000 election down in Florida. And before we really got into the intricacies of that act, the Supreme Court's resolution of the case in Bush versus Gore kind of ended the matter. But since then, there's been a whole lot of scholarship done. And most of it is confirmed with the written testimony I gave to the Florida legislature there. And it's that process that I want to focus on. Let me begin with the relevant provision of the U.S. Constitution that, Ray, you talked about earlier in your testimony this morning. Article 2, Section 1 provides that each state shall appoint in such manner as the legislature thereof may direct a number of electors to which they're entitled. The Supreme Court has described this constitutional authority of the state legislatures as plenary. That means it knows no other limit, that the legislature gets to do what it wants. That was in a 1892 case called McPherson versus Blacker, and it was reiterated by the Supreme Court in the Bush versus Gore case.
And that case was about, can the electors decide, can the legislature decide a different way to do electors? Could they do it by district instead of by popular vote? Because McPherson was very upset, or somebody was very upset that they wanted to do that. And the Supreme Court said, they get to decide. That's what they were saying. They didn't say that they can take that power back at any time. They said that it was plenary, that we can't overrule them. The federal government can't overrule the states. They decide how the electors are sent. But the Electoral Count Act that he's talking about says that those electors, the real electors, are the ones that are appointed by the laws of the state 6 days before the Electoral College meet. That's the safe harbor date. This year is December 8th. So if anybody wants to change, for example, Georgia wanted to change from appointing electors by popular vote to the legislature instead appointing them, they would have to have a law in place on December 8th. Right now, the law says popular vote. So he did mention the Electoral Count Act. That's what it says.
Back in 2000. It even is noted that whatever provisions may be made by statute or by the state constitution to choose electors by the people, there is no doubt that the federal constitution gives the right to the legislature to resume that power at any time. That's again McPherson, and the Bush versus Gore decision reiterated that. In the early decades of our nation's history, most state legislatures selected their state's presidential electors themselves. Only after 1824 did a majority of state legislatures move toward choosing their electors by popular vote. But your neighboring state legislature up in South Carolina continued to choose its state electors by itself all the way up until 1860.
Okay, is it 1860 right now? No? Okay, moving on.
Nevertheless, the constitutional power to decide on the method for choosing electors remains exclusively with the state legislatures.
Right.
Now, to be sure, the authority to take back that power.
And Georgia has decided to do it by the popular vote, along with 48 other states.
Power and appoint electors at any time, as the Supreme Court said in McPherson, would likely not allow a legislature to pick its own slate of electors after the results of a fair election, which had been conducted pursuant to the legislature's existing statutory procedures, merely on the ground that the legislature didn't like the outcome that the popular vote had chosen. As the Supreme Court said in Bush versus Gore, when the state legislature vests the right to vote for president in its people, the right to vote as the legislature has prescribed is fundamental. But that's not the case when the existing procedures are not followed. Right. And when significant statistical anomalies and other evidence.
This is what he's about to say. If there's laws about how to run an election, or procedures are in place about how to run an election, and those aren't followed in one precinct, if one person running the election doesn't put the tab properly on the breakage suitcase of the ballot, then the whole thing is, then the legislators get to pull it all back and appoint their own electors. That's what he's about to say.
Raising serious questions about voter fraud and about whether the election was fair. In such cases,
Serious questions, not proving voter fraud, just having questions about it.
the manner for choosing electors set out by the legislature was not followed. The constitutional default of the legislature exercising its plenary power, or rather resuming that power, is therefore again brought to the forefront. As the court noted in Bush versus Gore, the right to vote in an election for...
They aren't resuming the power. They've already delegated the power. They still have the power because they created the law. There's no resumption of power here.
Presidential electors is fundamental when done in the manner the legislature has prescribed. Now, what you've been hearing today is a lot of...
I should have been a lawyer. I could stand up in court against this guy and say, Your Honor, if it pleases the court, I would like to make you smile as I wiggle and jiggle. Huh? I rest my plate.
Of testimony about how the statutes that you had prescribed for the manner of choosing electors were not complied with. By the way, this is all in perfect line with federal statutory authority as well. Section 2 of Title 8 provides that whenever a state has held an election for the purpose of choosing electors and has failed to make a choice on the day prescribed by law, the electors may be appointed on a subsequent day in such manner as the legislature of such state may direct.
And the vote's already been certified in Georgia, so you're a little late there, buddy, because you're talking about the day, the safe harbor day is December 8th. It's already been done. Does not apply. No reason to talk about Section 8. It is moot. Like a cow's opinion.
The failure of state election officials to follow the manner you had set out in statutes in conducting this election, as well as the intermingling of illegal and legal ballots in significant enough numbers that the election can't be validly certified, quite simply means that the state has failed to make a choice on election day.
It has been certified. It's already done. He's not arguing in front of a court. He doesn't have the ability right now for a judge to overturn the election, to decertify the election. It's been certified.
In accordance with the manner that you prescribed. And the appointment of electors, therefore, both under Article 2 and Section 2 of Subtitle 3, devolves back on the legislature of the state, which has plenary power to decide whether and how to exercise the appointment power itself or craft some other mechanism to cure the problems with the state election that occurred. That is what the Florida legislature was prepared to do in 2000, prior to the resolution of that state's election controversy back in 2000. The vote on that day...
Guys, I'm sorry. I need like 20 seconds. I'll be right back. Talk amongst yourselves. Yeah. Oh, did you turn it on? No, I turned it down. Oh. It shouldn't have been. Sorry about that, guys. Here we go.
They had been certified by the Florida Secretary of State, but the state Supreme Court had, contrary to state law, ordered a recount in only heavily Democrat counties with the expectation that that would flip
Democratic. Okay, so we know this guy's a Republican.
the vote that had been certified. The relevant committees in the Florida legislature, both houses, crafted identical resolutions that would allow the legislature to reclaim its plenary power of choosing its own slate of electors. Those resolutions passed out of the relevant committees, and they were already scheduled for floor votes where they were expected both to pass when the Supreme Court issued its decision in Bush versus Gore, making that
But they're not laws. Resolutions are not laws. Let me show you what this is. Not procedures. This is 3 U.S.C. 5. Okay, I'll zoom in so you guys can see this as well. It didn't want to. Come on, there it is. Okay. I can zoom in a little bit less, and I want you guys to see the law to which I'm actually referring. Oh, for God's sake, you guys get out of here for a second. Sorry, I'm booting you out. If any state shall have provided by laws enacted prior to the date fixed for the appointment of the electors, okay? So, before December 8th, that's the day they have to appoint electors. For its final determination of any controversy or contest concerning the appointment of all or any of the electors, in other words, an election, by judicial or other methods or procedures, and such determination shall have been made at least 6 days before the time fixed for the meeting of the electors, December 6th, such determination made pursuant to such law, so existing on said day, law, not resolution, law, so existing on said day, so the law that exists on the said day, December 8th, and made at least 6 days, blah, 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 shall be conclusive, and shall govern in the counting of the electoral votes as provided in the Constitution, and as hereinafter regulated, so far as the ascertainment of the electors appointed by such a state is concerned. What they're saying here is, and this is federal law, this is USC, whatever method, whatever law, not resolution, law, whatever law was existing on December 8th, that's how you appoint the electors. Resolutions aren't going to do anything. They're not going to change the law. You can't do it afterwards. The law right now is that all of the electors are determined in Georgia by what? By the popular vote. That's all there is to it. All of this is nonsense.
Necessary. Violations of Georgia election law here, which is to say the manner that the Georgia legislature has established for choosing the president electors, are numerous. As you've been hearing testimony all day today, the number of underage individuals who are allowed to register contrary to the statutory authority amounts allegedly up to approximately 66,000 people. 2,500 people who are convicted and incarcerated felons.
No, the 8th is 6 days before the Electoral College, which is the 14th.
We're allowed to vote and have those votes counted contrary to state law. Proofs of identity that are required under state law were not complied with.
Not true.
Voters, as you just heard, moving from one county to another before a 30-day window, as the statutes allow, were allowed to have their votes counted and cast in the prior county of their residence.
Yeah, so here's what he's saying. Because some Georgia voters might have moved from DeKalb to Fulton County more than 30 days before the election happened, their vote should not count. And therefore, the entire election is void. Therefore, the legislatures, the whole popular vote thing, fuck you, popular vote. All of you Georgians who thought your vote counted, no, we're just going to pick our people. That's what he's saying.
Contrary to state.
Because somebody moved away 35 days from one county to the neighboring county, which, as you know, can be across the street.
State law. A number of voters don't even have registration of residential addresses, but P.O. boxes, and have been allowed to vote and cast ballots contrary to state law. I think the biggest one.
I don't know that law in Georgia, so I can't fact check.
As a result of the March 2020 settlement agreement that was entered into with your.
It's called a consent decree, but why would you know that, Mr. Lawyer?
Secretary of State and certain Democrat committee challengers that effectively altered the signature verification process for your absentee ballots in ways that are contrary to state law. Nope. Those state statutes are all designed to help prevent fraud, and yet their violations now then have created a serious problem with the potential for fraud. Just on the absentee ballots itself, the signature verification process normally results in the rejection of about 3 to 4% of absentee ballots for failing to include a residential address or for signatures that clearly do not match those on registration. Because of the changed procedures as a result of that settlement agreement, and that was agreement that was entered into without any involvement of the legislature, which means it was done contrary to the U.S. Constitution's authority in Article 1, Section 2. The rejection rates in this election were like 1/3 of 1%, with the resulting about 40,000 ballots.
No, they were about 0.2%, which, okay, let's not quibble about numbers, but he said that was agreed upon earlier this year, the consent decree between the Democrats and the Secretary of State, to try and make things more fair, or at least to try and outline things in the election, what was going to happen in the election. Here's the thing, though, as I've discussed earlier today, if you were watching, in 2018, the rate of rejections was 0.15. In this election, it's 0.2. So it's actually, the rate of rejection has gotten higher. And you still need signature verification. It's still in there. Nothing was changed. He thinks it was. He thinks that you no longer have to do signature verification on absentee ballots, only on the request. He's absolutely wrong, and I'll show you.
That would have been discounted or rejected historically were allowed to be cast and counted. That's a significant deviation from the manner that this legislature has set out. These significant statutory violations are, in my view, more than enough in the way of the alteration of the legislature's.
If the consent decree had said you don't have to do the signature verification on absentee ballots, he'd have a point. But that's not what it says. And in fact, the Secretary of State of Georgia has said, no, Trump is 100% wrong. This is Trump's idea as well, that he heard from Eastman or somewhere else, or Rudy or whatever. It's 100% wrong. What is wrong with Republicans and their comprehensive abilities? Comprehensive abilities. I'm sorry, I'm talking through Jello. Comprehension abilities. It's not what it says, and I'll show you. But before that, the Democratic senator is going to make her argument, and we'll look at it then.
Approved manner of choosing electors to warrant this legislature from taking back its plenary power to determine the manner of choosing electors. You could do that by calling a special election, although the time is very tight for that and may be logistically impossible. Yep. But you could also do what the Florida legislature was prepared to do, which is to adopt a slate of electors yourself. And when you add in the mix of the significant statistical anomalies and sworn affidavits and video evidence of outright election fraud, I don't think it's just your authority to do that, but quite frankly, I think you have a duty to do that, to protect the integrity of the election here in Georgia. These violations, combined with the significant evidence of fraud, in my view, strongly support the conclusion that something is amiss here, and that the legislature simply must investigate, as you're doing with this hearing today. And then if there's a result of this investigation, you're convinced that the election was conducted contrary to state law and too fraught with the risk of fraud to be properly certified, then you should exercise your prerogative to legislatively designate a slate of electors more in line with what the evidence of what actually happened on Election Day by valid votes demonstrated. Now, I also think it's important.
But we don't know what votes were valid and which votes weren't valid. Here's the thing. That's what his argument breaks down to, that you should take back your plenary power, which their power is delegated, that it hasn't gone anywhere. They created the system. That's their power. They haven't forfeited that power. They decided we're going to decide this way by law. They can't just ignore that law, because the U.S. law, the federal code that we just saw, says no, whatever law is in place, not resolution, not plenary power. But he's saying more in line, you should do it because it's more in line with the legal votes. If he's saying there were a bunch of illegal votes, there's absolutely no way to tell which votes were legal and which votes weren't. We don't know. If there's 100,000 fraudulent ballots, there's no way to tell.
That this legislature take the
They could be 100,000 illegal ballots for Trump. We don't know.
Action before next Tuesday, December 8th. And my apologies, I have a typo in my written testimony that I provided that said December 6th, because that's when this deadline for taking advantage of state harbor safe.
That's actually producer Rich helped him with that, so I get it.
Harbor provisions in federal law, Title III, Section 5 of the U.S. Code. Kicks in.
Yes.
But certainly before December 14th, when the electors.
He's literally quoting the law that I just showed you. The law that says, anyway.
Are designated by Congress to meet and cast their votes.
Yeah.
Only by such action can this legislature protect Georgia's right to choose electors for the election of president and vice president in accord with the statutory manner that you had set out well in advance of election day on November 3rd. And it's those electors that you decide need to be established that should be counted by a joint session of Congress, which begins at 1 p.m. on January 6th in 2021. Thank you very much for your attention. I'll be happy to answer any questions.
Are there any questions?
Thank you, Professor Eastman.
Senator Parent has a question. And
Senator
you're on
Parent.
number 6.
Yes.
Yes.
Can you hear me?
Yes, I can.
Oh, good. Thank you so much for being with us. I find all this a very interesting constitutional argument. So correct me if I'm wrong here, your argument is that essentially we have a failed election that would require the legislature to step in and assign electors. Am I correct?
Yes.
And what do you say in terms of proving that there is a failed election? What do you say to what's been laid out by our Secretary of State, Governor, Attorney General Barr, and the courts? Because right now there have not been, as far as I'm aware, proof of the number of ballots that would be required to have been problematic to switch the election and call it a failed election. I don't know where the evidence is. What do you say to that?
Well, there are two issues here. There's one, the extent of the fraud in the casting of ballots, and the other, which is undisputed.
Which she's talking about, but he said, like, let's not talk about
one of these today. I wanted to get your office's response to
I do not know who's talking.
From the Trump campaign this afternoon with the subject Georgia recount.
An 11 Alive investigation into
Okay,
Senator David Perdue.
That was another article I was looking at. I hate that when websites just start deciding to play stuff. Like, why? That was like 3 hours ago, and now you're going to decide, oh, we're just going to push to the brow. Anyway.
The failure to comply.
Yeah, he's talking about the fraud. We're not going to talk about the fraud, he's saying. Some rules were violated.
With the statutory scheme that this legislature had sent out. You can say that there's no fraud whatsoever, but if the statutory
Okay, let's say that.
scheme is not followed, the manner of choosing electors set out by this legislature, which has the sole authority to decide what that manner is not violated. It has been violated, and therefore the election is invalid, even without any evidence of fraud.
Well, can I ask you what is the statutory scheme that, in your opinion, was not followed?
Well, I recited several of the provisions of the state statutes that were not complied with in my testimony.
I don't have your testimony, sir. I apologize.
Yeah, no, that's all right. So I think the biggest one was the change in the signature verification process on absentee ballots. That was done as a result of a settlement agreement.
I'm aware
that did
of
not
that.
invoke the legislature.
Right.
Now, the problem with that is you had a judiciary and you had executive officials changing the statutory mechanism. The only authority to do that is the legislature.
So I understand
and the legislature
argument.
did not do that.
I understand the argument. Can I, and I apologize for interrupting. I just want to get sort of the things I'm really focused on answered. So the Secretary of State's position is that the law was not changed. They just, essentially, they said, this is how we're going to do it to ensure uniformity under the law through guidance to the counties, and the law wasn't changed.
That is correct.
Well, I mean, I've looked at the statute and I've looked at the consent decree, and the consent decree very clearly allows signature verification only of the signature on the application for absentee ballot, whereas the law requires signature verification of both the signature on the application and the signature on file with the registration card.
But
He is absolutely wrong, and I'll show you why. So what he's saying there is that it was changed so you no longer have to match the signature on the mail-in ballot. Let's just make it simple. Mail-in ballots. He's saying this new consent decree that you see before you here, it says and or that you have to match it either on the absentee ballot request or the absentee ballot itself. That's not what it says at all. Here's a section on signature match. It's very simple. Let me zoom in there. Oh, I'm just going to read it for you. You're going to have to trust me on this. County registrars and absentee ballot clerks are required, upon receipt of each mail-in absentee ballot, to compare the signature or mark of the elector on the mail-in absentee ballot envelope with the signature or marks in eNet, their online system, or on the application for mail-in absentee ballot. That's what is confusing him there. This is what it says. Every registrar or ballot clerk, when you get an absentee ballot, you're going to compare that signature to the signature we have on file in our electronic system or with the absentee ballot request. He's not saying it's a either or. He's saying you have to do it. Wait, he's saying you don't have to do it. He's saying it's an either or. The consent decree, which is a settlement agreement he's talking about, it says, yes, you have to do it. Upon receipt of each mail-in absentee ballot are required. They're required to do it. There's nothing there about either or. Well, there is no and or. There is an either or. You can compare to either the electronic signature on file or to if you have the absentee ballot request, you can compare it to that. Either one. But she's right.
Sir,
this is John C. Eastman. He's a buddy of Giuliani's.
From or to and is a significant change.
There, he just said that or to and.
Sir,
and the signature on file with the registration card.
But sir, that
change from or to and is a significant change.
I do believe that the procedure is you check them both, so there's signature verification 2 times.
She is absolutely 100% correct.
Not according to the consent decree. It says
that is absolutely wrong.
It says or, and that's a significant change.
It does not. We just looked at it. It does not say or.
Over the statutory scheme. It's only one of the significant changes.
Okay, but when
I give his claim a double jiggle.
That I recite in my testimony.
But would you agree that if the procedure is that they check it twice, that's actually preferable?
Yes, that's what the statute requires.
And I believe
but the consent decree allows it to be checked only once.
No.
The statute has a double protection there. The consent decree only has a single protection. And that's a change from the statutory protection against fraud that the legislature had adopted that was not complied with.
Well, you and I I'm not sure that's correct. I think it's checked twice. And I think that's what the guidance said. But
yes.
Can we move on? And what else was statutorily not followed that, in your opinion, resulted in a failed election?
Section 21-2-216 on registration of underage voters. They're allowed to do that up to 6 months before they turn 18, if they will be 18 by the time of the election. That was not complied with. People were allowed to register to vote more than a year ahead of their 18th birthday.
Okay, what he's talking about there is you can register in a lot of states before you turn 18 if you're going to be 18 on the election. So that way you can vote in the election if you're 18. Okay, so even if that was not followed to the letter of the law, the intent of the law is to allow people 18 or under 18 that will be 18 on election day to vote. Should you throw out the popular vote because of that? This guy's saying that you should. Because it makes no material difference whatsoever to the election. Nobody under 18 was allowed to vote. They were just allowed to register to vote and vote on election day if they were 18. He's saying we need to throw out the election because of that.
It looks like more than 66,000 people were illegally allowed to register and vote in violation of that statutory scheme. Felons were
They were 18.
Allowed to vote in violation of the statutory scheme. The failure to check.
Response to the release that went out from the Trump campaign.
Shut up! The same website did it again. I shut it off, and now it's okay.
Voter identity was, requirements of state statutes were violated. Those violations of the state statute. And let me give a comparison. In North Carolina in 2018, in the congressional district number 9 there, somebody violated state statutes by doing ballot harvesting that was not allowed under Florida law. Nobody demonstrated or proved that any of those harvested ballots had been illegally cast by people who weren't proper voters. Nevertheless, the violation of the state law was enough for the state election board to order a re-election as a result. I think the same thing has gone here with these violations of the state statutes.
And if I may very briefly wrap it up. Yeah, thank you, Mr. Chairman. I'm aware of the North Carolina situation. I think the difference that at least I feel is I haven't seen any evidence of any of the things that you're talking about. So we would need some sort of...
No evidence of ballot harvesting here. There may be evidence. There may be evidence of people under 18 registering to vote too early. But is that really the standard you're going to set? And then, of course, by the way, you've got your whole signature verification that he's wrong about.
Sort of court intervention. We would need a successful lawsuit. We would need the state elections board to take action the way you described happened in another state. And right now what we have is in our law 21-2501F, where the legislature has decreed that the candidate receiving the most votes is who the electors will represent. That's what we have in our law.
Well, with all due respect, the candidate receiving the most votes in an election conducted in according with all the other provisions of your state election law, when that was not done.
So if anything was violated anywhere at any precinct, throw the whole thing out. That's what he said. That's the standard that he's setting.
Done, you don't have a valid election. And this is exactly what happened in Florida when the state Supreme Court started ordering things on recounts that were contrary to state law. The Florida legislature didn't wait for a determination of a court to say our state law was violated. They made that determination themselves and passed resolution to protect their electoral votes. I mean, and it is their sole authority under Article 2 of the Constitution to do that.
So there's a lot of fraud that even the Attorney General of the United States has...
By the way, he's totally wrong about North Carolina as well. There it was a Republican who was paying people to go out and collect unfinished ballots from unsuspecting voters saying, oh, we'll take care of it for you. And then he would fill it in himself. That's fraud. That is proven fraud. And no, you're not allowed to harvest there either. But it was just in one district, but it was Republican. And that is probably the biggest example of fraud that everybody's heard of in the United States. Voter fraud is actually very, very rare. Thank goodness. But that was an example of people going out, collecting, and then filling it in themselves. We know for sure that was fraud. In fact, and that's why the election was overturned and they had a new election in that county.
Has not found? I'm
district, actually. Forgive me.
confused. I'm sorry. And
Well, you went back to the very first point you made. There doesn't have to be evidence of fraud, although I think there's rampant evidence of fraud, as you've been hearing.
There was evidence of fraud in North Carolina.
All day today. The mere violation of your state statutes is sufficient for this to be an invalid.
Right. So any election where any state statute is violated in any precinct whatsoever, not a valid election. It's completely specious.
Election and to return the power to determine the manner of choosing electors to this body.
Just dumb. Just dumb. Dude, I know you're a constitutional lawyer and everything, and I understand that right now I have a plate of Jell-O on my head, but your argument is just dumb at this point. Plus, you're wrong. You're wrong about two very important two very important components of your argument.
Senator Jones.
Dr. Eason's Burt Jones, Jackson, Georgia. Appreciate it.
All right, we're coming up on 5 o'clock local time. Tomorrow, for those of you watching, if you want to get in on the movie night, we're going to watch Elf tomorrow night. We're going to try and do it over Zoom. You got to have Zoom. We'll start that at 6 p.m. tomorrow. That's the timeline. Watch my Twitter feed throughout the day because that is subject to change. I'm betting, though, that we'll be able to start around about 6 o'clock. Reason being, I'm not doing anything on a Friday night, and I hope that I see all of you there. If you're not, so I'm going to send out an invite to all my patrons. So if you're a patron, you'll get one. Otherwise, if you're a PayPal and you've never actually used Patreon, I'm going to try and find my PayPals. Anybody who's Venmo'd me, if there's a way to contact you, I will. But if you've never patronized me, then please do send me a message on Twitter or try and send on YouTube. I don't know. Or as I'm broadcasting throughout the day, jump into the chat room and let me know that you want to do something. What someone just did a few minutes ago is they just sent me a message on Twitter, not a DM because I didn't follow them. They just said movie night. So at Kevin Lee Father movie night on Twitter, and I saw that and I followed them, and now I have their email address, and so we can communicate back and forth. Let's see if anybody else. And that was Tracy, by the way. So Tracy, I've got your stuff there. I see you sent me your email address, so we're good there. Marcy just did something kind of cool. I like this. There we go. Can you guys see all of that? Yes, you can. I love it. I love it, Marcy. It's my new favorite. Dr. Howard's husband's birthday is this Sunday. Congratulations. She's also high right now, which is probably why she's telling us that her husband has the birthday on Sunday. So that's good. It's tomorrow night is movie night. We're going to watch Elf, 6 p.m. And maybe I'll just be the shark, or maybe I'll let you guys request different things for my bubblehead tomorrow, because now that I figured out how to do this. I don't think, no, you don't have to install Zoom. In fact, I'd recommend not installing Zoom. My son is a computer engineer with the Amazons and doesn't recommend installing it just because it is suspected to be Chinese software and the Chinese can get a backdoor. I have to have it. So you can watch Zoom. You can just on your browser. So if you're using Chrome or whatever, you can use your browser. You can use your phone for doing it. But if we're watching movie night, I'd suggest a bigger screen. Anyway, did they close that loophole? So install Zoom if you want to. I have to have it on my computer so far. I'm not aware of any problems. I have to do auditions and stuff over Zoom, so I have it installed. But there is a way with your browser. When you go to a Zoom room, it says, do you want to start this in your browser or open the app? So if you don't have it installed, I think you're fine, guys. And then we'll see if it works. It may just be too choppy. It might be not unwatchable, but we'll give it a shot. And you don't have to have your camera, your mic turned on, etc. We'll work it out. So we've set on Elf because it's the Christmas season, and I have Elf, so I'm able to watch it. And we'll go from there. Anyway, good day today, guys. I'm probably done broadcasting today. I know I've done at least 4 hours, so I think we're good there. Oh God, we should watch Life of Brian at some point. Good idea. Okay, and yeah, I think we're done, guys. I think that's the end of it. I haven't had a chance to update the credits in between. I see there's more people in the credits now. Sean has to be added to the credits in the Pound Shame Club. The Pound of Shame. I like that. The Shaming Pound. No, we weren't going to watch Alf, not Alien Lifeform. Elf, the Christmas movie. But maybe at some point we'll watch Elf. I don't even know where to find Alf. Quite honestly, is it on the Hulu? I don't know. Okay, guys, till next time, this is Jellohead signing off.
Kevin, thanks for that.